the Erie Institute of Law presents Korematsu, 80 Years Later, Ramifications in 2025 and Beyond. This program was presented live on January 29, 2025.
The first speaker we'll have today is Mike Perley from Hurwitz. He is currently the chair of their litigation department. He's also the president and national board representative of the Buffalo chapter of the American Board of Trial Advocates. Mike will talk to us today about kind of the inception of the Korematsu case and what happened up to the decision. After that, we're going to hear from Kristin McMahon, who is the president of the Robert H. Jackson Center. She's going to talk about Justice Jackson's dissent in the Korematsu case and kind of being on the right side of history in what was an otherwise difficult case at that time. And then lastly, we'll have Wedade Abdallah, who is the managing attorney of the Regional Immigration Assistance Center at the Legal Aid Bureau of Buffalo. We're very excited for all these speakers. What we're going to do is each speaker has about 15 minutes to talk about their topic. We ask that we hold the questions until all the speakers are done talking, and then we have a lot of time for questions from those who are attending today. So without further ado, I'll pass it off to Mike.
Well, my microphone on. Thank you very much, Aaron, and thanks for the opportunity to be part of the program today. So I'm going to, I hope, cover the 80 of Korematsu. So to give you some sense of this, oh, here I go. I'm sorry. Fred was born in 1919 of parents who had emigrated from Japan in 1905. He lived until 2005, and after his death, there are some interesting things that happened as well. His family was, they had a flower nursery just outside of San Francisco, and this is a picture of his family. There's going to be a second one, which is actually a little bit better. Fred is standing in this picture right up front with the tie and the sport jacket on. His parents are to the left of the picture, and his siblings are to the right. Now, Fred got off to kind of a typical American start. He attended Castlemont High School, which you can see in this picture. He was a good student there and was, essentially readily accepted in the community. At some point earlier in his life, Fred attempted to enlist in the United States Navy, but was rejected because he had stomach ulcers. He trained as a welder and was working as a welder after his high school education. However, the attack on Pearl Harbor is a major shifting point, not only for Fred, but for all of the Japanese citizens in the United States who lived on the West Coast. So here's a bit of a timeline to help explain kind of the reaction that the Americans had. The last time foreign troops were on American soil was during the War of 1812. In 1814 was the last time the British were on our soil, and that was the last time foreign troops occupied any part of the United States of America. On December 7th, 1941, as we all know, was the Japanese attack on Pearl Harbor. On December 8th, the Congress declared war actually just on Japan. That is a misprint. We actually declared war on Germany on December 11th. I thought I had that corrected. So what was the reaction of citizens in the United States after the attack? And these are pictures from the West Coast around San Francisco. You don't have the entire picture in this slide, but it says grocery Wanto, W-A-N-T-O. And this family, and you can see Wanto Company in the window. This family made very sure that everybody that went by that store knew that they were American and they were not Japanese. Why? Because this was what happened to Japanese, right? I'm sorry that there's a second picture on the slide, but you can see a Japanese family and a sign that says, "Japs keep moving. This is a white man's neighborhood." And that was the reaction of many of the whites in San Francisco and on the West Coast, especially after Pearl Harbor. You can see in the lower corner of that picture on the screen, there's a Japanese woman pointing to the sign. And much of this also is generated through the government and especially affected Fred, who goes to great lengths to avoid going to an internment camp. After the war started, there was a concern that, number one, that Japanese Americans would side with Japan and would become agents of the Japanese on American soil, especially along the West Coast. And you may remember that during the war, the Second World War, there were blackout periods on both coasts for fear of invasion or airborne attacks. So on February 19th, President Roosevelt issues Executive Order 9066. When any commander deems such action necessary or desirable to prescribe military areas in such places and to such extent that the military commander may determine from which all persons may be excluded, he is authorized to provide to exclude those residents, and then at the bottom is provide for such residents transportation, food, shelter, and other accommodations. So this order starts the process by which General DeWitt will ultimately relocate the Japanese on the West Coast to internment camps. Yeah, the specific authority as well, and not just to relocate them, but to create internment camps for them. In March, now this is shortly before the internment camps order comes out in May, the Congress enacts and the president signs Public Law 503, which criminalizes remaining in a military area prescribed by the executive order of the president or by any military commander. So that if you stay in an area when you're supposed to be relocated, it is a crime. The next step in this process is 6 days later, when General DeWitt, commander of the Fourth Army, states that all persons of Japanese ancestry, both alien and non-alien, so citizens as well as individuals residing in this country legally, shall be prohibited from leaving military area number 1, which was coastal California, Oregon, and Washington, and that portion of military area number 2, described as the prohibited zone, which is Southern California and Arizona. This sets the stage for the next order to populate the internment camps, which was Exclusion Order 18, noting that all persons of Japanese ancestry, both alien and non-alien, shall be evacuated by May 1, 1942. Now I'm going to kind of go back in time a little bit. As these orders were coming out, and by the way, this is a copy of the poster that was set out. When we did a Korematsu presentation last year, the Jackson Center and Greg Peterson had a full-size version of the order. So let's talk about what Fred does here. Fred does not want to go into an internment camp. You can see a picture of him here. He has fairly heavy eyelids, typical of individuals of Japanese ancestry. So he had a girlfriend. She was in an Italian family. It was somewhat unclear as to whether or not that family really appreciated the fact that Fred was her boyfriend, especially after Pearl Harbor was bombed. So Fred took the extraordinary step of having his eyes redone by a plastic surgeon so that he would look less Oriental. He changed his name to Clyde Sarah, and he claimed to be both Spanish and Hawaiian and not Japanese. Now in the interim, these are the Japanese registering to go into the internment camps in compliance with the order. And I'm going to show you a picture of the internment camps in a minute. We're not entirely sure how, but Fred was in a store and he was wearing a pin that said he was Chinese, that he wasn't Japanese. And officers came in and they looked at him and said, "Are you Japanese?" He said, "No, my name is Clyde Sarah." Pretty soon, they knew that he knew the jig was up. They knew who he was, and he was arrested. And after his arrest, he was contacted by the ACLU. Ernest Zieg, who was the director of the ACLU in California, told Fred that they would represent him if, in fact, he wanted to contest it. He did. He was tried and convicted on September 18th, 1942, and that set the stage for the decision. While all this is going on, people are arriving at the internment camps. And this is them getting off the train. You can see that there are military there to ensure that nothing goes wrong. And this is a picture of an internment camp, except it's in Germany. That is a concentration camp in Germany. This is what the camps look like in the United States, and there is not a significant difference. If this picture was larger, you would see the barbed wire, you see the guard stations, and you see the areas where these individuals are being kept in quickly built houses. And actually, even before they were there, they were housed in the stables at raceways such as Santa Anita because they didn't have housing for them. That's what it looked like inside housing for a Japanese individual in an internment camp. You had a cot, you had communal showers and bathrooms, and you would live essentially in a square space, provisions for any. So let's talk about Fred after his conviction. Who I have left, Aaron.
That's funny. I had no idea.
You're about 4 minutes.
Okay. He was allowed to return to California. He married not his girlfriend, but someone else, and for a long time never spoke of his conviction and his internment until his daughter Karen, who I had the pleasure of meeting a while back last year, had a friend who got a book assignment, which was the story of Korematsu, and asked if it was about him because that was her last name. She didn't know. And when she came home, she asked her mother, and her mother said, "Ask your father." And she did. And all what Fred said was, yes, that was me, but they were wrong. According to Susan, he never, ever really was mad about it. Never blamed anybody, but thought that it was not proper. So good things happen now in the last 3 minutes of my presentation. Believe it or not, on February 19th in 1976, President Ford finally rescinds the Roosevelt Order 966 that allowed military commanders to do this. And in the 1980s, Peter Irons, who's a professor at the University of California in San Diego, decided to take up Fred's case and see if he could overturn it. And they found that the government had suppressed and failed to disclose exculpatory evidence. And on a writ of coram nobis in 1983, Judge Marilyn Paul Patel vacated Fred's conviction. After that conviction was vacated, he could finally vote. For that entire period of time, he was ineligible to vote in federal elections. There's a picture of Irons. He's sitting to the extreme right. Fred is in the middle, and another individual is to his left. 1980, President Carter forms a commission to investigate how all of this happened. And in 1988, there was a reparations bill. And if you were alive at when the reparations bill went into effect, you received $20,000. There's Fred with a letter from the government and the check for his reparations. And this is the only color picture by design, right? On January 15th in 98, I'm sorry, whoops. President Clinton awards Fred the Presidential Medal of Freedom. And then to cap it off, on January 30th, 2017, which is an anniversary of Fred's birthday, Google prepared the Google Doodle for Fred Korematsu, and you can still find it on Google. And they needed permission of the family, which they gave. The Fred, there's the Fred Korematsu Foundation, and they have formed this this program called the Fred Korematsu Day of Civil Liberties in the Constitution. New York City has adopted it, among others. Several states have adopted it. And it is now an ongoing program that they promote throughout the country. And Aaron, I think I made it.
You did. Perfect. Thank you so much, Mike. And again, everyone, we're going to have the presenters stay on until the end, and we'll ask all the questions of the group as a whole at the end. Thank you so much, Mike. We'll pass it on to Kristin, who is going to talk about Justice Jackson's dissent.
Also have a few slides to share. Michael, I'm impressed that you got through all of that in 15 minutes. Okay, so I want to introduce you to the Stone Court, which was from 1941 to 1946. And I want to lay a little bit of groundwork before we get to Jackson's dissent specifically as to what the court had been hearing during this time. So in 1942, you have Ex parte Quirin, which is a case of 8 German saboteurs who were arrested and tried by military commission on the orders of President Roosevelt. That case was argued on July 29th and 30th of 1942 and decided on July 31st. The question for the court in that case was, did the president exceed his authority in ordering a trial by military commission, thereby violating their 5th and 6th Amendment rights? And the court unanimously concluded that the president had not succeeded his authority because of the Articles of War passed by Congress, which specifically authorized trial by military commission for unlawful enemy combatants. And then we move into a pair of companion cases. So in 1943, we have the Hirabayashi versus United States case, as well as the Yasui versus United States case. And these are argued on the same day, and their opinions are read on the same day. Hirabayashi was convicted of violating a curfew order that required all persons of Japanese ancestry to be in their residence between the hours of 8 p.m. and 6 a.m. And then subsequently, his case ended up getting a little complicated. He also refused to relocate to one of the incarceration camps. So that was an added wrinkle into his case. But in this instance, the court considered the question of whether the president's executive orders and the powers delegated to the military violated the 5th Amendment by discriminating against citizens and resident aliens. And again, the court unanimously found that the executive orders and the curfew were constitutional because the restrictions on the Japanese and Japanese Americans served an important national interest. This opinion actually didn't address Hirabayashi's refusal to relocate. Just sort of ignored that part of what had happened. And similarly for Yasui, he was actually a lawyer. And he was specifically looking for a test case to challenge the curfew order. And ultimately, the test case became himself. He did not think he was an ideal subject for that because he'd worked for the Japanese consulate in Chicago, but he also wasn't really finding any volunteers to help with this. So he decided to take on that role. And again, and actually, the Yasui in the Yasui opinion, they refer back to Hirabayashi for all of really their justification, saying that Hirabayashi had already held that the curfew order was constitutional, and so as a result, Yasui, again, a unanimous decision for that. And then we come to 2 cases that were argued in October of 1944. And again, both of their opinions were read on the same day, December 18th, 1944. And I'll read Korematsu second, since that's what we're focused on here first. But the other case is Ex parte Endo. And Mitsuye Endo was a Japanese American who was fired from her job and moved to what they were euphemistically called relocation centers. And the court, in her instance, ruled that the government could not detain a citizen who was conceitedly loyal to the United States. Now, the court in this instance gave the president the opportunity to start closing the internment camps the day before they read their opinion. So their opinion was read on December 18th. The internment camps started closing down on December 17th. And that brings us to Korematsu. So Korematsu as well ended up having 3 dissenters: Owen Roberts, Frank Murphy, and Robert H. Jackson. Now, Owen Roberts had been on the court for about 14 years at this point. Frank Murphy had been on the court for 4 years, and Robert H. Jackson had been on the court for 3 years. Owen Roberts and Frank Murphy's opinions are very straightforward. They're very much focused on the racial discrimination aspect of this. Both of them had misgivings, I think is probably the best way to describe it in the earlier cases, but ultimately went along with what the majority court, since I mentioned that they were unanimous opinions there. In fact, Frank Murphy in Hirabayashi especially had intended to dissent, but Justice Frankfurter kind of cajoled him and convinced him to join the majority, largely persuading him that having a split in the court would be disastrous for the country during wartime. And really, for Felix Frankfurter, he wanted the court to stand with the other two branches of government. So that was his logic there. If you really read Frank Murphy's concurrence in Hirabayashi, though, it reads like a dissent. So he was clearly processing some of the challenges he had by going along with the majority. Similarly, for Robert H. Jackson, in Hirabayashi, he was a late joiner to the majority opinion. He'd also been a late joiner to ex parte Quirin, so he's definitely working through his thoughts on executive power and how they manifest itself. The notes from the Korematsu conference show a couple of really interesting things. One, that those in the majority really thought Korematsu should follow the same unanimity as Hirabayashi, Yasui, and Quirin. So the court was really trying to move forward with, we are one united front in this instance. Jackson told his colleagues, however, in that conference that he would stop with Hirabayashi. And his preliminary notes after reading the briefs in this case indicate that while he was undecided still, his initial inclination would probably be to reverse Korematsu's criminal conviction. And then for all three of the dissenters, Roberts, Murphy, and Jackson, what you really see is that the imposition of an evening curfew on an individual's freedom, they could justify that. They could balance that against the security concerns, against the military need. But that next step of relocating people, especially those for whom there was no claim of disloyalty, Fred certainly fell into that category, as did Hirabayashi and Yasui, was sort of like that next step. It was a bridge too far. And that really tipped the balance from a reasonable exercise into something that they did not feel they could support. I have a couple of quotes here in the next couple of slides. Jackson's opinion, for me personally, is not quite as straightforward as Roberts and Murphy's. Roberts and Murphy are very clear that their focus is the racial discrimination, and that's what their dissents are focused on. Jackson works through a couple of different issues within his dissent, and his dissent is only 6 pages. So if you haven't read it, I highly encourage you to do it. Or if you haven't read it recently, I highly encourage you to do it. He is really working through both how he feels about this particular case, but then also a conversation about the role of the court in these matters. So first, he starts with a similarly strong condemnation of the racism behind the military order. And that's really what this language here espouses. Personally, I love this language. This is actually one of the quotes I use most often from the case. I will say, as an aside, Jackson didn't really know any Japanese or Japanese Americans. What was in his head, and his notes indicate this, was because he came from Western New York, was the way that the Native Americans were treated in this area, and how easy it was to other them based on their appearance, which also was not something they had any control over, especially compared to the white Western Europeans of the area. And so that's part of his process in trying to determine how these citizens might feel and how best to put himself in their shoes. And this language very neatly tracks with what both Roberts and Murphy's language was. And to be honest, if his opinion had ended here, it probably would have been considered one of the most powerful and straightforward dissents ever written, but it also wouldn't require much parsing, and one of the reasons why I am here today. So let's get into the second part of his dissent. And this is honestly, I think, a part that has long created some confusion in readers of this opinion. This is really where Jackson takes a look at whether a civilian court is ever likely to impose constitutional limits on the military in a time of war. And so Jackson certainly believed these types of cases would come before the court. And he also felt pretty confident in saying that a civilian court would likely always defer to the military power, especially in a time of war. So, as a result of that belief, he was really cautioning civilian courts to consider and really to discourage them from even taking up such cases like this. As this quote indicates, there are two circumstances that seem pretty fixed for Jackson. One is that the civil legal process really lacks the competence to determine military necessity during war. And two, as a result, the civilian courts will always defer to the military's determination of necessity. Jackson is a very pragmatic lawyer and justice. And so this really, for him, was a caution against creating situations that Jackson thought could potentially destroy the legitimacy of the court and its power. He seems to be warning the court, and the Supreme Court in this instance, off future cases where the possibility might exist of the court striking down a wartime military order as unconstitutional, only to have the executive branch disobey it. And that would create an interbranch constitutional battle, which the courts, at least in the short term, would inevitably lose because it doesn't have an enforcement mechanism behind it. And so within that loss, though, as well, would really potentially shift the balance of power between the three branches and perhaps make the judicial branch less equal, perhaps even kick it out of that equality equation altogether. And Jackson's dissent, he was very clear on the role he thought that civilian courts had. He wrote that in sort of towards the end of his dissent as well, he refocuses on, well, what would he have done with Fred specifically? And at the very end, he wrote, I do not think they may be asked to execute a military expedient that has no place in law under the Constitution. I would reverse the judgment and discharge the prisoner. He was really concerned that the court in this instance would be upholding an interpretation of the Constitution that really had very specific limited use in time of war, but that could be used much broader. And, the language in here, I think, is one of his most famous lines about this information being a loaded weapon. This case and this opinion really stuck with Jackson all of his life. This is pre his experience in Nuremberg. His time in Nuremberg also really crafts and really shapes even more deeply the thinking he has on executive power and how that power is used. And in 1951, there's an article in the Buffalo Law Review called Wartime Security and Liberty Under Law. And Jackson, towards the end of that article, specifically references Korematsu and says, the precedent that I fear will long be most useful to justify wartime invasions of civil liberties is the Korematsu decision. And he wrote that Korematsu was a case where the government asked the court to become, in and of itself, the agency to enforce against the citizen, by a criminal process, a military policy of dubious constitutionality. And that he thought the courts should not lend themselves to its enforcement, and they should discharge the prisoner from custody under judicial commitment. But had the military authorities attempted to enforce the measure by their own force and authority, the court should not attempt active interference. And now I will turn it over to Wedade to share whether and how much of a loaded weapon this opinion has been.
Thank you, Kristin.
Okay, I am not tech savvy, so I hope this works, and I hope I pulled up the right PowerPoint. So, let's see. Okay, so I've been asked to cover the decision in Trump v. Hawaii. Trump v. Hawaii, also known as the Muslim ban case, was a case decided in 2018 by the Supreme Court that addressed President Trump's ban on individuals coming from certain countries. Can everybody see my PowerPoint? Okay, good. So people may remember that as a candidate in 2016, President Trump made a lot of vitriolic remarks about Muslims, including things like Islam hates us, Muslims don't respect us at all, and we need to have a total and complete shutdown of Muslims entering the United States. So quickly after inauguration, he issued the first EO, which suspended executive order, which suspended admission to the United States for nationals of Iran, Iraq, Syria, Yemen, Libya, and Sudan. There were 3 orders in total. You may recall the news at the time showed protesters and lawyers running to the airports to help people who were coming into the United States and were going to be subject to the ban to try to overcome that. There was the first legal challenge. It enjoined the first order. A second order was written. That order was also enjoined. In the second order, the Supreme Court decided that part of it could stand, but that others, people with connections to the United States from these select nations would still be allowed to enter. But on September 24th, 2017, the third and final iteration of the order was issued and included all of the original countries, but added Chad and North Korea and Venezuela. It was ultimately the order that was challenged in Trump v. Hawaii. Now, how does the Trump v. Hawaii case differ from the decision in Korematsu? Korematsu dealt with a military order ordering the relocation of Japanese Americans, and was an explicit race-based classification. It addressed the legality of the order enforced against people within the United States, including American citizens of Japanese descent. In Trump v. Hawaii, we're talking about a ban on foreign nationals coming into the United States using what the Supreme Court called a facially neutral policy directed at Muslim-majority nations. Both cases rely on similar legal reasoning that gives almost unfettered discretion and authority to the political branches of government on issues of national security and immigration. So there were 2 arguments before the Supreme Court, or 2 main arguments before the Supreme Court against the ban. One, that the executive order violates the Immigration and Nationality Act provisions, which prohibit discrimination based on national origin, and violates the Establishment Clause of the Constitution. So the Supreme Court upheld the executive order banning individuals coming from this country and rested its decision on the Immigration and Nationality Act challenge, saying that the act gives almost unfettered and exudes deference to the president and to the executive. So what does that clause of the INA say that the justices relied upon? In regards to the suspension and entry or restrictions by the president, whenever the president finds that the entry of an alien or any class of aliens into the United States would be detrimental to the interests of the U.S., he may, as he deems necessary, suspend the entry of any alien or class of aliens. So this is really, the crux of immigration law, is that the executive branch has the power to exclude people. The Immigration and Nationality Act also has a provision raised by the challengers of this order that says that you can't discriminate against individuals based on national origin. So these 2 provisions were in conflict. The way I believe that the justices who upheld the order applied them. Clearly, there was a discrimination against individuals based on national origin, but really it was based on their religion, since all of these countries are Muslim majority countries. They did add North Korea and Venezuela to the executive order that was ultimately challenged, but as Justice Sotomayor noted in her dissent, people from North Korea are not free to leave their country and come into the United States in any event or in any great numbers. And the Venezuelan ban only related to certain government officials. So this really was a ban against people from Muslim majority nations. And the executive order was written in a way that discussed extreme vetting. What is that? It's that when you're coming into the United States, you have to go through certain applications and tests and background checks. And the order said that the countries on this list did not uphold the standards that the United States required to allow the entry of these individuals. So the justices really, in defending this and upholding this EO as constitutional, relied on this provision to the detriment of the Establishment Clause, and not staying whether or not the president's use of this statute comported with the ultimate law of the land, which is the Constitution. So what did they say about the religious animus part of the order? So essentially, they ignored all of the president's previous statements discussing why he wanted to put this order in place, including as a candidate. But even after the third travel ban was initiated, the third executive order, the president said that, it's very hard for Muslims to assimilate in Western culture. Completely ignoring all of that information, Justice Roberts says that this case before them differed from conventional Establishment Clause claims, that it didn't involve prayer or infringing the beliefs of a person from within the United States, but rather, it was a security measure to make sure that those coming into the United States were not a danger to the U.S. But incredulously, Roberts says that the order doesn't even include the word Muslim. It doesn't say anything about, religion at all. So it's facially neutral towards religion. It's just, looking at backgrounds and security checks and clearances and whether or not, these nations can, control their travel documents. But I mean, if you read the decisions, Roberts really, it acts as though he's totally confused about why they would even raise the issue of religious animus when nothing is said in the order, when all of the evidence is to the contrary, when looking at all of the facts available to the court at the time. So this decision in Trump v. Hawaii in relation to immigration is not unusual, because the history of immigration is a history of exclusion. There are good decisions from the Supreme Court, regarding some immigration cases, providing due process, for removal, not allowing for indefinite detention. But really, when they're talking about people coming into the United States, the history of immigration has been one of exclusion, and you can draw a line directly from, the first cases on immigration law in the United States related to Chinese exclusion. It's a tradition of the court, I think, to give complete deference to the executive and to the legislative branches in these areas, to the detriment of the Constitution, without considering the Constitution. And it gives them broad authority to essentially deny constitutional protections to people. So if you go back to the first Chinese exclusion cases in 1899, you have an opinion by Justice Field upholding a decision to exclude Chinese nationals in writing on behalf of a unanimous bench, said that if Congress considers the presence of foreigners of a different race in this country who will not assimilate with us to be dangerous to its peace and security, its determination is conclusive upon the judiciary. And you see a straight line from that, I think, to Korematsu, who refused to reject as unfounded the judgment of military authorities, saying, who are we to tell the military what is necessary to make the country safe? We're not in charge of that, and we're going to allow extreme deference in those situations. And then you have very similar reasoning by Chief Justice Roberts in Korematsu, who says that the arguments that Trump's policy is overbroad or does little to serve national security interests, we can't substitute our judgment for the executive's judgment on such matters, all of which are delicate, complex, and involve large elements of prophecy. So who are we to say that the executive is wrong in trying to protect the United States or in making laws on who can come into the United States? So the one thing this opinion does is overturn Korematsu explicitly, although, for a long time, people discussed, the wrong holding in Korematsu and not following Korematsu. Here, Justice Roberts decides to rightfully say that we're taking this opportunity to make express what is already obvious, that Korematsu was gravely wrong the day it was decided and has been overruled in the court of history, and to be clear, has no place in law under the Constitution. And he cites to Justice Jackson's dissent in Trump v. Hawaii. But the reason he does that is because Justice Sotomayor, in her dissent, goes right for the jugular and says what the court is doing here is reinstituting Korematsu. It's just repackaging it, and it has everything to do with this case. Justice Roberts says that this is different. The forcible relocation of U.S. citizens to concentration camps, solely and explicitly on the basis of race, is objectively unlawful and outside the scope of presidential authority. But it's inapt to liken that morally Republican order to a facially neutral policy denying certain foreign nationals the privilege of admission. So again, there's that difference in who is in the United States, within the borders of the United States, as opposed to the rights of those coming in. Interestingly, there was a decision only a few months ago, Munoz v. DHS, where this issue was again brought to the fore, where a U.S. citizen woman said that she had a constitutional right to have her non-U.S. citizen spouse live in the United States with her. And the justices decided against her. Her husband was, not barred for being a criminal, not barred for any reason other than that the consular thought he may be involved in criminal activity, and said that she did not have a right to have her U.S. citizen spouse live in the United States with her, and that he certainly did not have a right to come into the United States just because he was the spouse of a U.S. citizen. And there the court invoked the issue of consular non-reviewability, which is also something that was raised in Trump v. Hawaii, which basically says if the consulate makes a decision, who are we to judge it? And in fact, we can't judge it by the laws of the United States. So I think the good thing that comes out of this is that the court overturns Korematsu. What do I think the benefit of that is well, it's saying that we can't intern or put people within the United States in camps and discriminate against, people living here, which as a Muslim American, as a Palestinian American, means a great deal to me, because I remember after 9/11, there were rumblings about interning Muslims and Arabs after the attacks of September 11th. And those we took in my community very seriously and were very fearful of. So this has some meaning to me as a targeted group within the United States. It doesn't put any constitutional limits on the political branches of government when it comes to national security or immigration on people coming in. So I think that is still a big problem, and really has been historically part of the court's decisions in cases like this. So I think that is probably the one good thing that came out of Trump v. Hawaii, but I really think it is just Korematsu repackaged and saying that if our government can come up with a facially neutral written policy, forget why it was actually enacted, but written policy, we're going to uphold it and not second guess it. I think that's my time, right, Erin?
It is. Thank you so much, Wedade. Really
Okay.
appreciate it. And thank you again to all our presenters.
The code on the screen is FRED, spelled F-R-E-D.
So with that, I know there were some questions in the comments. We'll get to those shortly. And also, someone pointed out that we're gonna give these materials that you saw today. We're gonna pass those along to you guys in a subsequent email. So one person did call me before the CLE who wanted to share something with the group. And is Miss McCready on the line? I think she's here.
Yes, can you hear me?
Yes.
Okay,
Go ahead.
all right. Good afternoon, everybody. I went to law school with Justice William O. Douglas's last wife, Kathy, and became close to her because there were only 8 women in my class of almost 300 students. And this is while he was on the bench still. And he and Kathy came to my apartment for a party, which was a great honor. And one of my guests asked Justice Douglas if he had any regrets or would change his vote in any case. And he took about just as long as it took to take in a breath of air, came back with yes, Korematsu v. US. And went on to explain that he deeply, deeply regretted his position in that case. So I thought that you all would be interested to hear that.
Thank you, Maureen. All right, we have some questions from Holly first. Holly Baum, would you like to ask your questions? And you're muted right now. Just make sure you unmute.
Well, basically, the thing that strikes me as the most obvious question is if we were at war against Germany and Japan and only Japanese Americans were interned, what does that tell us about what was really going on?
So
that's basically the question.
So I will field this, although I will also preface this by saying I'm not an expert. So my understanding is that there were actually some small internments of German and Italian Americans, but very, very limited. And one of the challenges, especially with that, is that someone of Japanese or Japanese American ethnicity is much more visually identifiable than someone of German or Italian descent. And so, you know, that was a particular challenge. Also, and to be honest, the historic record seems to show this quite clearly. General DeWitt really distrusted the Japanese Americans, and a lot of his orders are based in that racism. There, you know, fairly recently, also there have been some news articles about the Solicitor General did have additional reports of showing that there was no real threat from Japanese or Japanese Americans on the West Coast, that they deliberately did not provide and were not factored into the record for this case. So, you know, it really, I think to your point, yes, it's just a very clear showing of the racism against, I'll say Asians writ large, but specifically the
Right.
Japanese and Japanese Americans in this instance.
That's what I thought. Okay, thank you. Do you want me to do the second question? Sort
Yeah,
of
go ahead.
rephrase it?
Mhm.
All right, so assimilation, and this is, I'm sorry, to our third speaker. That whole notion seems to me so, obviously problematic, because when they talk about who can fit into the country, are they talking about culture, or are they talking about actually people who align themselves with the values of American democracy? Because clearly there's a distinction between groups that have no problem being tolerated as long as they're perceived as having the right cultural agenda or religious agenda or whatever it is, that may be inconsistent with the Constitution and democracy. Could you comment about that a little bit?
Well, I guess I don't understand your question. Is it that there are people who deliberately exclude themselves from society and don't align with the society in which they live, so that maybe it's warranted?
No, what I'm asking is, I mean, the justification is that certain groups can assimilate based on where they come from.
Right.
But we tolerate as a nation certain groups that self-isolate and don't, quote, assimilate into the larger communities, if you will, right?
Right.
And we also tolerate groups that want to, certain religious expressions are accepted as sort of natural to the country as opposed to alien to the country. So I guess I'm saying, well, go ahead.
I think the answer is that how easy is it to these other groups, right?
Exactly.
If you can identify them by name, if you can identify them by how they worship or where they worship or how they dress, it's easier to say that these groups are the problem. It's also when you describe any act committed by an individual, associated or part of that group by their identity. So you will rarely hear that we've arrested, a white Christian male for X, Y, and Z. But almost inevitably, you'll hear that a person is Muslim. And if a person is Muslim and they're arrested, the immediate question is was it terrorism based? Even if it's a larceny, it's not even a joke to say that, but it's just the way we're trained to see people that helps our government and our courts to and maybe encourages it to look at people and say, this is the problem because all of these people within this group are doing this. And you can see it on the news when you only see that because that's the way we choose to describe and identify people, right? Because it's easy. It's easy because they look different or they sound different or their names are different, and that other people might blend better despite their animus, like militia groups or insurrectionists.
That's my point, but also
Right.
the definition of who is an American. It's not based on your identity as accepting democracy and the Constitution. It's based on certain religious or Western cultural normalities. So what are we talking about in terms of who is a true American? And that whole thing is clearly where we are right now in some cases, in
Every
many
person
cases.
who naturalizes has to take an oath to defend the Constitution and to uphold democracy. So I think,
No, I agree with
if,
you. I'm
yeah,
talking about how this
I
is being
understand.
played out. Yeah,
I understand. Thank you, Holly. I understand. Thank
thanks.
you. Mhm.
Right, other questions for the panelists?
I'd like to ask a question to Wedade. It's Sophie.
Hi, Sophie.
Hi. Isn't the fundamental difference, and I think you said it, but the fundamental difference between Trump v. Hawaii and Korematsu, the fact that people who are not present in the United States are not constitutionally protected?
Yes,
Are
that
you
is
advocating that is a flaw in the legal system?
So the INA states at, it's 8 USC 1152 A1A, that no person shall be discriminated against on admission to the United States as a
Right.
non-immigrant or an immigrant on the basis of sex, nationality, place of birth, or place of residence, okay? But you and I know, Sophie, and immigration practitioners know that there is no right to admission to the United States. The Constitution doesn't protect people outside of the United States. The question here, and the plaintiffs in Trump v. Hawaii were the university and family members. People were trying to bring relatives in. The university was hiring people from these countries. The question is can the executive make violate the Constitution by making a law which discriminates on the basis of religion and also violates that provision of the Immigration and Nationality Act, which was also enacted by Congress, to say we're not
Right.
going to do this. So all of this is based on the laws as we've written them and as we've decided them. And we put that anti-discrimination into the INA. So we
Yeah.
can't discriminate on that basis. So I think that's the thing here. The issue here is there a reason to deny them to make them inadmissible, to deny them admissibility based solely on
That I get.
their
That I get.
religion? And, are you using this as a pretext to commit, to discriminate against a
Right.
person on that basis?
I
which
get that. I
violates
just struggle with the idea that there's a constitutional violation when someone is not protected by the United States Constitution.
Except
But
the
I
INA
think the
says it.
fact
Yeah.
that the INA says you can't discriminate is a powerful provision.
And Congress shall make no law abridging the freedom of speech, religion, right? So,
but that's-
just because they're outside doesn't mean that they can write unconstitutional acts or uphold unconstitutional laws which violate other laws and our Constitution. So doesn't mean that people have a right to come in. It just means that you can't discriminate against people on that basis. That's the way I read Trump v. Hawaii. But I think this decision is going to be particularly important when we're looking at people within the United States and what protections they have, because there are people who, although they're here, we consider not to be here. They're not admitted, and what protections are afforded, what due process protections are afforded to those individuals as opposed to people that we've allowed to come in.
Something yet to be seen.
Yeah, Sophie, we're waiting.
Before we get to
Waiting.
Carmen's question, someone did ask in the comments if some of the panelists would be open to answering questions after the CLE, maybe via email. So if you were on the panel and you were comfortable with that, if you could just share your email or contact information in the chat so people can send you some questions. So Carmen, what's your question? You're muted, Carmen. Sorry. I think you're still muted. If you just hit the microphone button toward the bottom left of the screen, it should unmute you.
Thank you.
Mhm.
Got it? A distinction in Korematsu, it was mentioned that there were not many Italian or Germans as Japanese. I think the orders pertain to Italian nationals, Italian aliens and German aliens who are not citizens. But with Japanese, it included those of Japanese ancestry, which included not only Japanese aliens, but Japanese citizens. So I think there's a distinction there regarding why there were many German Americans or German and Italian, not rounded up, I guess it's the best word to say, rather than Japanese, because ancestry included citizens and non-citizens, but it was limited to aliens for Italians and Germans. Joe DiMaggio, the baseball player, his father was an Italian alien. He was not a citizen, and he was rounded up and put in a camp. That's all I wanted to say. Thank you.
Thank you, Carmen. Other questions from people in the audience?
That concludes our program. Thank you for watching.